not specifically say the 5-minute phone call.
That's the problem. That's the problem you're faced with, because that's the first inference that your opposing counsel is attempting to rely upon for her inference stacking argument. Your case basically was a motive and opportunity case. Would you agree with me on that?
And identity, yes, Your Honor.
Right. But I mean, you got to identity because you said the defendant had motive and opportunity.
Yes,
It was
correct.
entirely an identity case, and the way you got to identity was motive and opportunity.
You're right.
You had no physical evidence.
I have no physical evidence, but it's not an entirely circumstantial case.
Okay, what's your direct evidence in this case?
The defendant's statements in 2 telephone calls from the jail.
That the state had her hair to compare with the hair that was found on the casing, right?
Yes, in part, but not only that the state had her DNA to compare to the hair that was found on a shell casing collected from the scene, but also the defendant's worry that we had her hair, her DNA, to make that comparison.
Right, which could be interpreted at least 2 ways, which is that she's guilty and she's worried you're going to find her out, which was your interpretation.
Yes.
Or could be the state has my hair and they could fake it. It could be interpreted that way. So that's that evidence. The other thing is her phone call with her sister in which she expresses relief that a witness has died.
She has celebrated.
Because that witness is the only witness who can place her in Kansas during the relevant time period, correct?
Yes, Your Honor.
Okay. So you have those 2 phone calls. Those are circumstantial. That's not direct evidence. That's not an admission on her part.
It is not an admission.
Okay.
It is a statement against interest as I interpret it.
As you interpret it, but it's open to interpretation.